Hi, good afternoon, everybody. It's 12:02 on my watch, so we'll get started. First of all, thanks for everybody attending. Nice to see a good turnout. So my name is Mark Vyvyan. I'm a shareholder in the litigation and real estate departments at Fredrikson and Byron. Among my areas of practice are workouts in foreclosures. And with everything that's going on in the world, in particular the downturn caused by the pandemic, we likely are going to be seeing, and already have seen, more distressed properties, which, as most of you know, will lead to distressed loans, and some of those may lead to foreclosures, while some of those instances may be worked out successfully between borrower and lender. So I'm going to be talking about those topics, trying to give a general overview of Minnesota law on workouts and foreclosures. I always welcome questions. It makes it more interesting for me and I think for everybody. So if you have a question, feel free to put it in the chat feature, and I will monitor those as the webinar proceeds. And I will also allow, the last time I did this talk, there was about 10 or 15 minutes at the end for questions, and we'll try to get you out of here at 1 or before. So let's get started. If I can get my slideshow to start. There we go. Before we get into foreclosures, let's talk a little bit about pre-negotiation and forbearance agreements, why you might consider them. So pre-negotiation and forbearance agreements are more common, in my experience, amongst institutional lenders that are not in this market. And we'll talk a little bit about what the agreements consist of, especially with pre-negotiation agreements. Well, I'll go to the next slide. So the terms in the pre-negotiation agreements, you can sort of do what you want with them, and there's a lot of typical terms. But really the essence of them is a lender saying to a borrower, you're in trouble, you're in default, or maybe about to go in default. Borrower, you want to talk about working out this loan, getting some concessions. And the lender saying, you know what, before I even talk to you, borrower, I'm going to make you sign a multi-page agreement that gives away certain of your rights. So that type of agreement is easier to ask for if you're sitting in an office in New York and you've never actually met the borrower face-to-face. For most of my community bank clients, you don't see a lot of pre-negotiation agreements because there's a pre-existing relationship. And when a borrower is asking for assistance from a lender, in that circumstance, in sort of a personal relationship circumstance, it's harder to ask for a pre-negotiation agreement, in my experience. So with that in mind, we'll talk a little bit about the provisions in typical pre-negotiation agreements. First thing you'll often see addressed is what I've described as the terms of negotiation, in terms of timing, location, making sure that nothing said during the negotiations will be admissible in later proceedings. To some extent, this reminds me of the Paris peace talks, where they spent a lot of time arguing about the size of the table and the shape of the table. But it can be good to spell out the terms of negotiation so everyone knows what to expect. Second typical provision is identifying who is authorized to speak on behalf of the borrower and the lender. Again, if there's a personal banking relationship, sometimes often banks will transfer responsibility for a troubled loan from the initial loan officer to a special assets department or something similarly named. And if the authority to deal with the borrower has transferred internally at the bank, you want to make sure the borrower knows that. And similarly, the lender wants to make sure they know who is authorized to negotiate on behalf of the borrower. So that's a typical provision you'll see in a pre-negotiation agreement. Third one, and this is a benefit to the lender, all these terms are mostly to the benefit of the lender, is an acknowledgement and reaffirmation of the debt. You want to make sure that the borrower acknowledges they are indebted and the amount. This has become, I think, even more important in the time of COVID, because you're seeing a lot of borrowers make arguments based on force majeure and commercial impossibility, and they may want to make an argument they're not actually obligated to make certain payments. And as a lender, you want to make sure that they acknowledge that they are, in fact, bound to do that. Another point is acknowledgement and reaffirmation of the validity and enforceability of the documents. Sometimes borrowers, when they're in trouble on a loan, will make arguments that there was lack of consideration for a loan document initially, or other similar arguments. As a lender, you want to make sure that those arguments are weakened or removed to the extent possible. So that's another typical pre-negotiation term. If there's a guarantor involved, you're going to want that guarantor to acknowledge and reaffirm his or her obligation under the guarantee. You want to make sure that the borrower acknowledges that the lender is waiving no rights by discussing a workout of the loan or entering into any sort of negotiation. Similarly, you want to make sure if you can get the borrower to waive all their defenses to enforcement of the loan documents. That is obviously a very good thing for a lender to get. You know, sometimes you'll have a borrower that won't agree to that. They may think they have a really good defense, and they may make the decision that it's better to not negotiate with the lender. They'd rather keep the defense that they may have. So sometimes borrowers push back on that. If they do, I think lenders want to look at that carefully and really fully assess what exposure they may have on that borrower's alleged defense. Release of claims against lender is also a nice thing to get in a pre-negotiation agreement. If the borrower is claiming some sort of lender liability, some bad act by the lender, getting a release of all those claims is beneficial to the lender, obviously. You want to make sure that the borrower is going to agree to pay the lender's expenses in the course of the workout negotiations, including the lender's attorney's fees. The underlying loan documents typically include an attorney's fees provision, but it's always a good idea to get additional consent and agreement that even the workout fees, short of litigation, are an expense of the borrower. Another thing it's nice to have in your pre-negotiation agreement is a specific acknowledgement that there is no deal until a written agreement is executed. Sometimes borrowers will think a deal has been struck based on a handshake or a comment. You want to make sure that everyone agrees that there is no deal until a written agreement is executed. Sometimes you can get away without this due to the credit, what I call the credit agreement statute, Minnesota Statute 513.33, which essentially says the same thing, that there's no oral agreements. But it's always good to get a specific acknowledgement. Another thing that's nice to include is a borrower acknowledging that they are pursuing alternative opportunities. Sometimes a borrower will make a claim later on that they relied on something the lender said or did in the terms of the workout, and as a result of that, they forwent opportunities to get financing other places. So included acknowledgement that the borrower has the chance and is actually pursuing other opportunities is always a good requirement to have in your document. Similarly, an agreement that the borrower is going to cooperate with workout efforts and lender executing its rights or exercising its rights is a benefit as well. And finally, typically you see a provision that each party really, the lender though, has the right to terminate the negotiations at any time. So those are the typical provisions you see in a pre-negotiation agreement. So what do you see in a forbearance agreement? Well, you're going to see many of the same types of provisions that we just talked about, especially in acknowledgement and affirmation of the debt, a release of claims. Those types of things are very common in forbearance agreements. But you're also going to see, this is not surprising due to the name of the agreement, you're going to see forbearance terms, which, for example, could include how long a lender is going to forbear from exercising its remedies, whether the borrower is going to continue to make payments during the time of forbearance. Often you'll see the amount or the frequency of payments modified as a condition of forbearance. You may also see a modification of collateral, either because a borrower is going to liquidate some collateral to get funds to pay the lender, or you may want additional collateral to increase the bank's position. You may also see a modification of reporting requirements. Often you'll see the bank asking the borrower for more documents to see what's going on with the business and really assess the borrower's viability and potentially the value of the collateral. You may also see additional monetary or other items to the benefit of the lender, and sometimes you'll actually increase performance obligations of the borrower during the time of forbearance. And you'll see a default provision in forbearance agreements that says if the borrower defaults under any provisions of the forbearance, that the lender is entitled to proceed with all of its remedies, either under the forbearance agreement or also in addition under the underlying loan documents. So voluntary resolutions. So in the process here, we've talked about a pre-negotiation agreement. If you get one signed, you may also have a forbearance agreement. But if it comes time to actually resolve the matter, can that happen? What are the options? Well, there's obviously the remedy of foreclosure, which is typically an involuntary resolution. So we're going to talk a little bit about ways that the borrower would voluntarily work out the troubled loan. And there's primarily two methods under Minnesota law that can happen. The first is a deed in lieu agreement, and the second is a voluntary foreclosure. A deed in lieu, as its name indicates, is a deed to the real property given in lieu of, instead of, foreclosure. These, and we'll talk a little bit about why you might want to pursue that in a minute. Voluntary foreclosure is a type of foreclosure that the borrower consents to, and there's a specific Minnesota statute that we'll talk about in a minute that deals with that. Deed in lieu considerations. So if you're considering taking a deed in lieu, here are a few things to think about. First, as a lender and you're considering a deed in lieu, is really, do you want to own the property? The answer may be emphatically yes. It's a good property. You think you can resell it. You may want it. But you may also be in a situation where, for instance, is there some environmental issue with the property? Is it not a desirable property overall? Is it something you want to stay away from with a 10-foot pole? That can be. If you don't want the property, don't take a deed in lieu, because the main benefit of a deed in lieu is getting title to the property quickly without having to pursue a foreclosure, which dovetails into the second thing you want to consider here is the status of title. The most attractive circumstance for a deed in lieu is where there are no junior liens against the property. If there's no junior liens that need to be wiped out, a borrower can sign a deed to the lender. Lender can take title to the property and proceed to sell it and make itself whole or close to whole in that circumstance. That's sort of the ideal circumstance for a deed in lieu. A less ideal circumstance for a deed in lieu is if there's a bunch of junior creditors and junior liens against the property. Because in that circumstance, if you need to get rid of the junior liens to foreclose the junior liens, that's where foreclosure sort of comes from. If you're going to have to do that, there's in some respects you may as well foreclose because you're going to have to foreclose at the end of the day anyway. That makes a deed in lieu less attractive. Keeping in mind that you may need to foreclose your mortgage, even if you take a deed in lieu, always be sure to discuss with your counsel the inclusion of what's called anti-merger language in the deed. And where this anti-merger concept comes from is at common law, if in this circumstance, a borrower's interest under the mortgage, if the lender's interest under the mortgage, if the lender later takes fee title to the property, those interests as owner and as mortgagee can become one, which would wipe out the mortgage, which would prevent it from being foreclosed later. So if you need the ability to foreclose later, be sure to include anti-merger language that will have the effect of preventing those two interests, the interest as owner and the interest as mortgagee, from merging and extinguishing the mortgage. Voluntary foreclosures. Voluntary foreclosures are available for commercial properties, and they have a few benefits and burdens for each party. From the burden on the lender's side, lenders waive the right to seek a deficiency judgment, and borrowers waive the right to reinstate the loan by paying what they owe. So each party gives up something here. Another thing that the borrower gives up is consenting to appointment of a receiver to operate the property. So the main benefit of a voluntary foreclosure is, as a lender, you know your borrower is not going to fight you. And the other benefit is it's faster. We're going to talk a little bit about non-voluntary foreclosures, and those typically involve a 6 weeks published notice of sale. In a voluntary foreclosure, that period of time that you need to publish a notice of the ultimate foreclosure sale is reduced to 4 weeks, which makes the process faster, obviously. And the other benefit is a shortened redemption period. Most redemption periods for loans in Minnesota are 6 months. A voluntary foreclosure involves a 2-month redemption period. So if you have a property that's commercial, a cooperative borrower, and you have some junior liens that you need to wipe out, a voluntary foreclosure can be pretty attractive. It gets you the property faster. You give up a few things like deficiency, but oftentimes the deficiency is not going to be worth much anyway if the borrower is not collectible. So voluntary foreclosures can be an attractive route to go. So let's talk now about non-voluntary foreclosures. There's 2 methods of non-voluntary foreclosure in Minnesota. First is foreclosure by advertisement, which is referred to as a non-judicial type of foreclosure. In the non-judicial references, there's no court involvement. Foreclosure by advertisement is a statutory creation that involves publication of a notice of sale after default. It's published in a legal newspaper. The sheriff conducts a foreclosure sale, and then there's a redemption period afterwards. So the benefits of foreclosure by advertisement are that it's faster and typically cheaper. The second method of foreclosure under Minnesota law is foreclosure by action, which is a judicial proceeding, meaning that you have to start a lawsuit. The lender has to start a lawsuit against the borrower and potentially a guarantor for the right to foreclose. So because there's a lawsuit on the front end of a foreclosure by action, it is typically more expensive and takes a longer time because you need to litigate the case, seeking what's called a decree of judgment or a judgment and decree of foreclosure, which gives the lender the right to proceed to publish notice and have a sale. So the 2 methods of foreclosure look similar at the end in that there are both publications of notice and ultimately a sheriff's sale, but the beginning of the process is quite a bit different because in a foreclosure by action you have a lawsuit. So why would you choose one or the other? Typically, historically reasons to choose foreclosure by action is if there's some sort of title dispute, if there's a defect in the mortgage, if there are a priority dispute among lien claimants. There's some reason you would want the court to look at the foreclosure and sign off on it. That is a good reason to choose a foreclosure by action. Also, you see that I've referenced the Ruiz decision. Ruiz decision came down maybe 6-7 years ago now and talked about errors in the process of foreclosure by advertisement and what the effect of those was. And in Ruiz, there was a rather minor defect in the foreclosure by advertisement process. There had been an assignment of the mortgage, and that assignment was not of record at the time the foreclosure started. Now, the foreclosure by advertisement statutes require that assignments be of record at the time the process starts. In this case, it wasn't. There wasn't any dispute that the mortgage had been assigned. It really was a technical defect. And what the court in Ruiz said is they don't care if it's a technical defect. If there's a non-compliance with the statutory requirements, the foreclosure is void. Not that it's voidable, that it's void. So lenders would need to start over in the foreclosure process, which is not welcome after you think you have title and are getting ready to sell the property to learn that you have to start over. So Ruiz, I think, has pushed more people into doing foreclosures by action because there's a greater certainty attached to that type of foreclosure than pursuing a non-judicial advertisement. I want to talk a little bit now, before we get into the more specifics, about the impact of the governor's executive order and the CARES Act. The executive order was really involved just a request for a moratorium on residential foreclosure or residential foreclosures. So it never really required anything that prevented foreclosures. The CARES Act did impose a moratorium on federally backed loans on residential properties of 1 to 4 units. And that moratorium just recently got extended to August 31st. So if you're trying to foreclose a federally backed single-family mortgage loan, you're going to have to wait until the end of August. So that's something important to keep in mind. Foreclosure by advertisement. Let's talk a little bit more about the process. When you're starting on either really a foreclosure by advertisement or foreclosure by action, first thing you want to do is get title work to figure out what junior lien claimants are out there, if any, and how you're going to need to deal with them. And you also want to make sure that your mortgage is of record and there's no issues that could trip you up there. So you want to work with counsel to get title work ordered, probably an update of existing title work, existing title policy, and make sure that you know what the lay of the land is. The next step involves a notice of power of attorney, which is a document required by statute to be recorded, giving the attorney the right to foreclose the mortgage and also giving notice of the proceeding to people who are interested. That's recorded in the real estate records. After doing that, you need to serve, publish notice of sale for 6 weeks in a legal newspaper. The notices can be long, and it's not uncommon for a legal newspaper to make a mistake in publishing. So when I do a foreclosure by advertisement, I like to leave an extra week or 2 in there to make sure that if the notice needs to be corrected, we can run a correct notice for at least 6 weeks. You also need to serve that notice of sale on the occupants of the property. This is a little bit of a quirk under Minnesota law. You would think that service on the mortgagor was required, but the statute only requires service on occupants. Now, while that sounds easy, oftentimes it is not, and there's timing and difficulties associated with that. And I'm going to flip to the next slide to talk about an issue that I dealt with. So this is a picture of a house that we were doing a foreclosure on for a bank that had a mortgage that involved multiple parcels, most of them agricultural, and a few of them also had homes on them. And we sent the process server out to serve all the occupied properties, which we believe we did. We got a call from the borrower saying, no, you didn't serve me. Well, where do you live? And they gave me the address. Well, this was the address. And I called the process server and they said, no one lives there. I said, all right, well, this guy says he does. I called him back. Process server says you don't live there. I sure do. Process server went back out and took this picture and some others. So this property to me does not look like it was actually occupied, but it created enough of an issue for us that we actually postponed the sale and served that alleged occupant personally at a different location. So if you're dealing with a borrower that you think is going to be difficult to the level of essentially lying about whether they occupy a property, just be aware of that if you choose foreclosure by advertisement, because it can present some issues. So in addition to serving the notice of sale, there's a number of additional notices required for residential properties about giving residential borrowers notice of their opportunity to redeem, notice of their right to designate part of the property as a homestead. There's a number of notices. They actually are required to be on different colored sheets of paper. So there's a lot of traps for the unwary there. So you want to work with your counsel on that. After 6 weeks published notice, you get the occupant served. Really, the culmination is a sheriff's sale, which is conducted as a public auction by, it's not typically the sheriff, him or herself, but typically someone delegated with that task in the sheriff's office. Sheriff sales are really boring. I think people think, I love auctions, but this is the most boring auction I've ever attended. Everyone I've ever been to, the notice of sale is read. They ask for bids. The lender is the only person to make a bid. Properties sold, going once, going twice, sold. and the sheriff issues a certificate. They're usually short in duration and not very exciting. But at the conclusion of a sheriff sale and a foreclosure by advertisement, the sheriff will execute a certificate of sale, which the foreclosing attorney will then record in the real estate records. Let's compare and contrast that to foreclosure by action. Like a foreclosure by advertisement, you're going to want to start with title work. And you need the title work to identify who you need to name as a defendant. So Minnesota law requires that everyone claiming an interest junior to the mortgage be added as a defendant to the case. And the reason you need to do that is you're only going to bind those parties that had claims at the time of commencement of the action if you name them as a party. So if you want to foreclose a junior creditor and you don't name them, the judgment typically does not bind them. So you really need to be careful about who you're naming as a defendant and make sure you get everybody. After you do your title work, you name the correct defendant, you're going to start your lawsuit. You're going to have a summons and complaint. You're going to serve it on all the defendants. At the same time you're starting your lawsuit, you also want to record a notice of lis pendens in the real estate records. A notice of lis pendens is a document that gives notice to the world through its recordation in the real estate records of the existence of the foreclosure. The reason you want to do this is that is the document that will give notice to junior creditors that may have an interest that arises after you start the lawsuit. So as long as you record your notice of lis pendens, someone may obtain a junior interest after that, but if it's obtained after the lis pendens has been recorded, they too will be bound by the foreclosure by action. So like the foreclosure by advertisement process, there are additional notices required for residential properties, most of which should be served at the time you start the lawsuit. So after you get the lawsuit started, the litigation process is pretty similar to any other district court litigation process. If necessary, there's discovery done, could be depositions, motion practice, maybe a trial. The litigation procedure is pretty similar to any other case, which means that it can be expensive and it can last a long time. Once you have judgment, which is really what you want, a judgment and decree of foreclosure, you can go ahead and start publishing your notice of sale. Like a foreclosure by advertisement, you need to publish a notice for 6 weeks in a legal newspaper. On a foreclosure by action, there's an additional requirement, though, of posting. That same notice of sale needs to be posted in 3 of the most public places in the county for 6 weeks as well, which this is more of a tip for practitioners, you want to make sure that you and the sheriff's office are on the same page about who is publishing and posting. Some sheriff's offices want to do everything themselves. They want to get the notice, they want to publish it, they want to post it, they want to control everything. Other offices want to have as little control as possible and expect you to deal with publishing and posting. And either method really is fine, you just need to know which method it is. I had a colleague that had a sale that was ready to go, and the issue of posting, despite the fact she discussed it with the sheriff forgot to post the notice, which meant the sale needed to be postponed. So you want to check up on those things ahead of the sale. So sheriff's sale is conducted in a foreclosure by action in the same way that it is conducted in a foreclosure by advertisement. The difference comes after the sale. Instead of getting a certificate of sale right away, what you get is a report of sale, which says who it was sold to and for how much. It's then incumbent on the foreclosing attorney to bring a motion to confirm the sale before the district court. So you'd be going back to the same judge that you had the underlying litigation in front of and asking him or her to confirm the sale. There's very limited objections on a motion to confirm sale. Typically it would be the publishing and posting procedure was not followed correctly, or the amount of the sale is so insufficient as to shock the conscience. You'll see lots of borrowers complain about the amount bid. It might be too low. They may think that the lender is trying to create a deficiency judgment. Case law in Minnesota is pretty tough for borrowers on that. Unless it's so low as to shock the conscience, courts are going to confirm a sale, even if the amount may be less than the property is actually worth. Once you have the the motion to confirm sale conducted and granted, you take the order confirming back to the sheriff, have the sheriff sign a certificate of sale, and then you go record the sheriff's certificate. One thing to keep in mind here, we'll talk about redemption in a second. In a foreclosure by action, the redemption period, instead of running from the date of sale, runs from the date the sale was confirmed, which can be confusing. I'm going to talk now about reinstatement and redemption. The terms often are used synonymously, but they are different, and a lot of people do misuse them. Reinstatement applies before the sale. So it's essentially the right to pay what you owe and avoid a sheriff's sale altogether. And the right is created by Minnesota statute 580, I don't know, my screen is blocked off there, 580.30 creates a statutory right of reinstatement. In some other states, there's a common law right of reinstatement, but in Minnesota, it's actually codified. And that statutory right of reinstatement applies even if the debt has been accelerated. Typically, your loan documents are going to include a provision that says if you miss one payment and the borrower is given notice and they don't cure that, it accelerates the entire amount of the debt, the full mortgage debt. The statute is clear, and the case law interpreting the statute is clear that reinstatement rights of borrowers apply even if the debt has been accelerated. They really just need to pay the amount that's past due, not the entire amount, the amount that's past due, interest, and costs. They also need to pay attorney's fees, and there's a formula to determine that under 582.01. I won't bore you with the formula because it's fairly complex, but your lawyers can certainly figure that out. Redemption rights. So redemption applies after the sale. So just to be clear here, reinstatement is before the sale, redemption is after the sale. The typical redemption period in Minnesota is 6 months. There are some circumstances where you can have a shorter redemption or a longer redemption. A 12-month redemption period can apply if a significant pay down of the debt has occurred. So if you have a situation where a borrower has paid more than 33% of the debt, a third of the debt, they have a longer redemption period. They have a 12-month redemption period. If the property is agricultural, you're going to be looking at a 12-month redemption period, or if it's over 40 acres. So the requirements for the 12-month redemption period are relatively complex. That's something you want to go over with your lawyer. But the key things to look at, has a significant pay down occurred? Is the property agricultural? Or is it over 40 acres? So redemption, it applies after the sale. In both mortgagors and junior creditors have the right to redeem. Mortgagors have the first chance to redeem. And that right applies after the sale in the event of a foreclosure by advertisement or after confirmation of the sale in a foreclosure by action. Mortgagors will pay the amount to redeem, pay the amount bid at sale, plus interest and costs incurred thereafter. And that redemption right applies throughout what is typically a 6-month redemption period. Now, junior creditors have the right to redeem thereafter. I have a question here, let's see. So question about thoughts. I'm just going to take the question right now. Thoughts on a deed in escrow as part of a forbearance agreement. You definitely see people do this. So the concept, at least as I understand it, would be having a forbearance agreement that says, borrower, you're going to make certain payments. If you don't, borrower, you have given me a deed that I can go record and take title to the property that way. The main problem with pursuing the deed in escrow route is that a savvy borrower will claim that the forbearance agreement is essentially an equitable mortgage and you still need to foreclose. So an equitable mortgage is a circumstance where there is some document, it's not usually called a mortgage because that would be an explicit mortgage, some document that conveys title to real estate but is really an additional security device. So in this case, a deed in escrow would be, you'd be using the deed held in escrow as additional security. And if that was the intent of the conveyance, the deed in this case, under Minnesota law, there's a lot of cases saying that would constitute an equitable mortgage. And if it does constitute an equitable mortgage, you would have to foreclose it. So in terms of whether you want to do it or not, there's really not a reason. You're not going to be any worse off, I guess, because you already have a mortgage. If you create an equitable mortgage that you need to foreclose, you would have had to foreclose it anyway. So I don't think you're hurting yourself. It just maybe doesn't provide the greatest level of certainty. If you're hoping to achieve certainty, a deed in escrow is probably not the best way to go. But if you want to get title to the property and let the borrower raise it later, yeah, I mean, it would get you title to the property. Whether or not, the borrower can challenge it later would be the question. So I'm not opposed to that route. It's just not certain. Redemption rights. So as I mentioned, they apply after the sale. Mortgagor has the first chance to redeem. Now, if a mortgagor does not redeem during its redemption period, then the junior creditors have the right to redeem. So there's a lot of complex procedures and requirements that apply here. A couple things to mention. You need to file a notice of intent to redeem 7 days as a junior creditor, 7 days before the expiration of the mortgagor's period. And the reason for that is so the parties can figure out who's going to sort of be on the dance floor, who has the ability to redeem as a junior creditor, and what order they can redeem in. Because they're going to redeem in order of priority, the most senior priority down to junior priority. And junior creditors like the mortgagor would have to pay the amount due either on the share certificate plus interest and costs, or the amount paid by the previous junior creditor. So in the periods for junior creditors are 7 days. So each junior creditor in order of priority, if they have filed a notice of intent to redeem, has 7 days to do so. And you can redeem either through the sheriff or through the holder of the certificate of sale. So if you have a cooperative certificate holder, it's probably easier to redeem through them. If you want to make sure that you can do it, even if someone tries to prevent you from redeeming, sheriff would be the way to go. But yeah, the rules are pretty complex, so it's definitely something you want to talk about with counsel. Appointment of a receiver. So appointment of a receiver primarily is controlled under Minnesota law by Chapter 576.25, which 576 was amended a few years ago, sort of clarify these. There's two types of receivers under Minnesota law, general and limited. This really deals with a limited receiver. A limited receiver is most often appointed during the context of a mortgage foreclosure, and really is appointed to run the property as opposed to running the borrower's entity. So when can you get a limited receiver appointed in a foreclosure? Well, if you have a loan that's $100,000 or more, an original principal amount, and it's not a homestead, a residential property with less than 4 units, or ag land, and you started a foreclosure, you get a receiver appointed if you ask. You're going to have to bring a motion to the court to get a receiver appointed. You see them most often appointed, I think, in foreclosures by action, because you already have a lawsuit pending that you can bring the motion in. But if you have a foreclosure by advertisement, you can still get a receiver appointed. You just need to start a court proceeding. So if you make the showings that we talked about, you have the right to get a receiver appointed. There's also some additional, ways to get a receiver appointed under 559.17, but that's getting a little bit too far in the weeds. One thing I want to talk about is, I think sometimes lenders think if they want to have any sort of access to the property at all, they need to get a receiver appointed, which is not totally true. Receivers, to me, are most effective if you have an income-producing property that's generating rents, and you want to get a hold of their rents under your assignment of rents. That's where you see most appointment of a receiver. And you want to make sure that getting a receiver appointed actually makes financial sense, because you're going to have to incur the cost both of bringing the motion, and lenders are typically required to front the compensation cost of the receiver. So if a property is kicking out $200 a month in rent, you're probably not going to want to pay to have a receiver appointed, especially if your only interest is to get in there and make sure it's secure. And the reason for that is Minnesota law also creates a limited right of entry into the property under 582.031, and allows you to secure the property and then add the cost of securing the property onto the amount you can bid at sale, or the amount required to redeem. So if you just want to get in there and make sure everything's okay, mortgagees rather, have a right to do so under Minnesota law. Deficiency judgments. So deficiency judgment is a money judgment that a lender gets against the borrower for the amount by which the debt owed exceeds the bid at the sheriff's sale. And the amount of deficiency, this is an important item, just checking my time here. The amount of deficiency is determined at the time of sheriff's sale, as opposed to time of a later sale to a third party. So if you want a deficiency, you need to bid in a deficiency, meaning a lot of lenders will just bid their full debt and the cost. If you bid the full debt, there is no deficiency because the debt is equal to the bid at the sale. So you would need to bid less than the amount owed to get a deficiency. I've seen some lenders, I've seen lawyers make this argument that, well, yeah, we bid a certain amount at the sale, but we sold the property 2 years later for much less, so we should get a deficiency. That argument doesn't work. The case law in Minnesota is pretty clear on that. So if you want a deficiency, you need to make sure you create one at the sale. Another key thing about deficiency judgments, they are not available against a borrower in a foreclosure by advertisement with a 6-month redemption period. So if you have a property that's 6-month redemption period and you want a deficiency judgment against the borrower, you cannot foreclose by advertisement. If you do, you will lose your right to a deficiency. So in that circumstance, you'd want to foreclose by action. So that limitation on deficiencies against borrowers does not apply to guarantors. So if you have a guarantee of a mortgage loan, you may have given up your right against the borrower to get a deficiency judgment, but you can still get one against the guarantor. Keep this in mind as well. Some savvy or thoughtful lenders and lawyers, at least in one circumstance, said, hey, how about we just name the borrower also have them also sign a guarantee, and then we'll still be able to get a deficiency judgment against them. There's a case saying that you can't do that. So that one's a little too tricky. And there's also some general limitations that are 582.30 on deficiency judgments, especially if there's ag land. There's some things to be aware of there. So that's the prepared portion of the presentation. I would be happy to take questions if there are any additional questions, either through the chat or through the Q&A feature. There's a question. Okay, question. Where should a layperson looking for residential property to buy that has gone through foreclosure, and should they retain counsel when buying that property? Does Fredrikson represent such buyers? So, you know, in addition to, you could probably retain a broker to help you look for properties. What I know a lot of people do that are interested in properties is develop a relationship with people in the local sheriff's offices, and they maintain a file of the recent foreclosures, at least in Hennepin, that you can go in and look at. In terms of retaining counsel, yeah, we do represent buyers in this circumstance. The issue of retaining counsel, to me, if it's an area that you're just getting into and are not experienced, I would retain counsel because just because a mortgage got foreclosed doesn't mean it was done correctly. So if, for instance, there was failure to give a proper notice or something, the foreclosure either may not be effective or it may not be effective against a junior creditor. So you'd want somebody to take a look at that. So to answer the questions, I would go look in the sheriff's offices for properties. I would retain counsel until you got comfortable knowing that you know what you're doing. And yeah, we'd be happy to represent people in that circumstance. Let's see. Oh, I answered that. Got another one here. Please explain ag land deficiency limitations. So The main limitation is if you're seeking a deficiency on ag land, there's actually a requirement that you start a separate proceeding, and I always have to look at the statute. I think it's within 3 months, and the borrower is entitled to a jury trial. So this was enacted, I think, in the 80s when there was a lot of farm foreclosures, and people in the legislature thought that that farmers were being taken advantage of. So there's just some additional hoops to jump through if you want to get a deficiency against agricultural land. And the main one is starting the action within a certain amount of time and the ability of the borrower to have a jury trial. Anybody else? Okay, I'll stay on. If people have questions, I think Bill asked the question about ag land. If you want more information on that, Bill, feel free to email me. I can put a little more meat on the bone if you have a specific situation. Okay, just to clarify, a lender cannot obtain a deficiency against a guarantor of a corporate borrower if foreclosed by advertisement. No, so sort of the opposite. So a lender could not obtain a deficiency against the corporate borrower if you foreclose by advertisement with a 6-month redemption, but the guarantor, assuming the guarantor is a separate entity from the corporate borrower, you can obtain a deficiency against the guarantor. That limitation on deficiencies with the 6-month redemption period and foreclosure by advertisement applies to the borrower, not the guarantor. You're welcome.
There's a question in chat.
Oh, okay. Okay, if there are, say, 3 junior lead holders, does that add 21 days to the foreclosure? So the answer is maybe, it depends. So if there are 3 junior lead holders, you're for sure going to have to go through the whole mortgagor's redemption period. So the issue then becomes, do those junior lien holders file notices of intent to redeem? If each of those junior lien holders added or filed a notice of intent to redeem, yes, the redemption periods would be extended by 21 days. So I'll tell a story that's a little bit illustrative of this. I had a client that foreclosed a residential property with a very difficult borrower who, among other things, tried to run the loan officer over with his truck. So he was a difficult borrower. We foreclosed the mortgage, 6-month redemption. We go to evict him and learn that he had granted junior mortgages in the last few days. So I think it was 7 of his friends and family. And the reason he had done that is the statute that deals with eviction after foreclosure is a little bit ambiguous and just talks about being able to evict a borrower after the redemption period is over. It doesn't differentiate between a mortgagor's redemption period and the junior creditor's redemption period. So his game plan was, gee, if I file or if I grant these 7 mortgages and they each have 7 days to redeem, if they file a notice of intent to redeem, then I have another 49 days to stay in the property. We didn't think that was the right answer. There's actually case law on both sides of that issue. One case says, you know, if it's a mortgage and it's recorded, we're going to assume it's valid. And there's another case, I think from the 1890s, where a lawyer actually was being foreclosed upon, and he just sat in the county recorder's office and granted mortgages to people every 5 minutes all day long. and the court in that case said this is obviously a fraud and we're not going to abide by that. So, so a little bit of a lawyer's dream in the case that I had because there was case law on both sides. So we ended up agreeing that he had 14 days to stay, that we weren't going to give him the full 49, he took 14, and then we evicted him, had the sheriff serve the writ on him, and I knew we were in trouble when the sheriff called and said, "Was that house under construction?" I said, "No." He said, "It sure looks like it's under construction," and that was because the guy had taken everything of value, including the controls for the in-floor heat, out of the house. So, so that was a long-winded answer to your question, but yes, if there's 3 junior lien holders and they each file a notice of intent to redeem, there would be a 21-day extension to the redemption period. Anybody else? All right. Well, I thank everybody for their attention. If you want to email me, it's mvyvyan@fredlaw.com, or feel free to give me a call at 612-492-7005. Thanks, everybody. Thanks for joining.